apartment is locked, so with the trunk in the back, and I know my rights, so you gonna need a warrant for that.
Aren't you sharp as a tack? You some type of lawyer, somebody important or something.
I ain't past the bar. I know a little bit enough that you won't illegally search my shit.
See how smart you are when the canines come.
All right, folks, welcome back. In our last set of videos, we saw how Brandeis fought to have the court recognize what he called the right to privacy in the Olmstead case in 1928. The court, the majority in Olmstead, basically said that since the defendant's property hadn't been entered or opened in order to glean the information heard on a wiretap, then the Fourth Amendment couldn't offer protection. A wiretap was just not a search for purposes of the Fourth Amendment. But Brandeis replied that a person should expect privacy in their phone calls, not a property right in them, because that would require the entry into some sort of physical space, but a privacy right in those phone calls. So to put it in terms of what he said in the 1890 article, The Right to Privacy, which we also looked at, a person's voice or telephone calls are elements of their personality that they are projecting beyond their body in some sense in order to represent the most intimate meaning of their life. So regardless of whether they were doing this on or doing this using their property, they had a right to be let alone, in his famous phrase. They had a right to be let alone in doing this thing, making this telephone call. It's not that the police could never wiretap. They just need a warrant, according to the Fourth Amendment, because they shouldn't be stepping into such an intimate area in people's lives without probable cause. Yet, it wasn't actually until Katz versus United States in 1967, that Brandeis's idea of privacy seemed to capture a majority of the court. Seemed. That's an important part of this video here. Katz articulated what came to be called the doctrine of reasonable expectation of privacy, and it extended a new protection against wiretapping, which would be a protection not only inside the home, but even outside of the home, as we'll see. But it turned out to be stated in an ambiguous way in the Katz majority decision, and later justices, for reasons that we'll look into, decided it only actually meant to protect a person when they entered private places outside the home. And we'll see in our test case when we meet in class that that distinction matters a lot, a distinction you're going to learn a lot about in this video, so bear with me. Okay, so it's clear that privacy was the new philosophy in Katz, but some people ended up thinking that it had to be connected to a particular place in order for the words of the Fourth Amendment to apply to it, that you could have privacy in a place. You'll remember that the amendment mentions protections for persons, houses, papers, and effects, its wording. And then it says that a warrant has to specify the persons to be arrested, the place to be searched, or the thing to be seized. It's very particular, I pointed out to you in those videos. So some of the justices in Katz, and many justices afterwards, said that privacy might be the sort of protection that a person, which is an entity mentioned in the amendment, that a person could expect even outside their home, but they could only expect it if they were in a place that the government had to enter in order to search. So a person mentioned in the amendment could expect privacy in a place also mentioned by the amendment. So for them, Katz announced a privacy rule, but it made it property or place-based, not connected to personality in the way that Brandeis had suggested. Then in our second of these videos, what we're going to learn is that just a few years after Katz, the court heavily qualified its holding in U.S. versus Miller and then Smith versus Maryland. So not only was there ambiguity in the Katz decision, allowing some people to interpret it in the way that was more property-based, in a way that offered, in some circumstances, fewer protections for the privacy of the individual, but then the court went and highly qualified its privacy ruling, again, It did that in Miller and Smith and etc., indicating that there was a strong contingent on the court that didn't want an expansive privacy ruling like Brandeis would have pushed for. So they wanted a privacy ruling of sorts, but not the type Brandeis would have pushed for. So in these cases, Miller and Smith, they said a person could not have an expectation of privacy, the words from Katz, in things that they shared voluntarily with a third party. So this came to be known as the third party doctrine, and we're going to learn about it. So for instance, if I told my bank that I was writing a lot of checks for $20,000 to a particular person so that the bank could cash them, information they would need to know to cash those checks, that info might no longer be private under this doctrine. And now perhaps my purchases, whatever they were, they might just be payments to a contractor who's building a home for me, or they might be payments to my drug dealer. They're not quite as private as I myself might have wanted them to be. Like I said, this came to be known as the third party doctrine, and it greatly limited the number of things extended beyond the body that I could expect would be kept private. So let's take a look at all of these cases, starting with an extended consideration of Katz. Okay, the facts. Charles Katz was an LA resident involved in sports betting. In fact, he was fairly famous for setting odds on college basketball games. Now, if betting is illegal in your area, you probably don't want to be famous for it. I'm not going to claim that's part of the lecture. It's not on the test. It's just a bit of free legal advice for you, okay? So the feds, obviously, because of Katz's well-known status, they knew quite well what he was up to. They knew he also used a public telephone booth near his house on Sunset Boulevard to communicate betting information across the country. So they attached a microphone to the outside of the telephone booth and they recorded him doing his betting stuff. If it makes a difference to you, what he was doing was handicapping, or in other words, setting odds on the games. So he was arrested and he was charged with a federal crime of engaging in sports betting across state lines. The feds didn't have a warrant for this, but two courts that heard Katz's case said that because the FBI's eavesdropping device did not physically penetrate the telephone booth's wall, no Fourth Amendment search had occurred, and so the FBI did not need a search warrant to place the device. This was not a wiretap in this case, notice, but a microphone on the outside of the booth. So, in quite literal terms, they were only listening to the sound waves that went beyond or outside of the booth, the place. Okay, so in doing this, the lower courts used something like the Olmstead logic, but notice that in this case, they were actually being somewhat more protective of privacy than Olmstead had been, because they said Katz would have been protected beyond his own property, including the property that he had stepped into, which was the phone booth, but there had to be property, a place involved. Some courts had already started doing this by 1967, in other words, allowing people to sort of carry their property right from place to place with them. So for instance, if you entered, say, a friend's house, the cops would still need a warrant to search because you were now in another protected property or place. Indeed, what the courts called this was a constitutionally protected area, an important phrase. They used that phrase to sort of generalize from the Fourth Amendment's particular mention of places and houses and so on and so forth. So constitutionally protected area. And with this, lower courts had actually begun to move beyond Olmstead a bit, as I suggested, extending protections outside the home, but they had remained tethered to Olmstead in two other ways. First, a person had to enter a constitutionally protected area wherein he would have that right. And second, the cops would have to physically penetrate or trespass into the protected area in order to violate that right. So their ruling was still place-based. And the FBI knew this, that courts were ruling in this place-based way. They knew that Mr. Katz had sort of carried his Fourth Amendment protections into the phone booth with him, but by this very logic that courts were using, anything that went beyond the phone booth wasn't protected by a property-based or a place-based rule. And indeed, the lower courts that heard Katz's case did, as expected at the time and as expected by the FBI. They said that since the relevant property, the phone booth, hadn't been entered in any way, then Mr. Katz couldn't claim Fourth Amendment protection. But the U.S. Supreme Court ruled 7-1 in favor of Katz. They questioned the lower court's analysis of the case in terms of property-based theory, and in the end, they threw out the Olmstead decision. So the Supreme Court decided to view the situation in the way Katz himself would view it, and how other reasonable members of the public might view the situation as well. If he thought that he was not extending information beyond the boundaries of himself or his personality, to paraphrase Brandeis's words here, and if other reasonable people would have thought that too, then he was doing something private. He was not making his actions or his words public. If he and others would think of entering into a phone booth as protecting their words, making those words private, then their words, not just the place of the booth, were protected. And here's what the court said. This is the rule that they articulated. The Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection, but what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. So, to apply their words, what Katz sought to preserve as private, even in an area accessible to the public, like the phone booth, should remain private, at least without a warrant, meaning that the cops would have to show probable cause to do the monitoring first. Okay, well then, what did Katz do to indicate that he subjectively understood his communications to be private and, quote, sought to preserve them as such? Well, simple. He entered the phone booth, right? Simple. Oh, wait a minute. If that's what the court actually said in this case, they'd be requiring that he enter a place, again, in order to get the protection of the Fourth Amendment. That's what the lower courts had done. That's what courts had been doing for a little while, expanding upon the Olmstead ruling. So if that's what they said, the phone booth was important, their sound and fury about overturning the lower courts and throwing out Olmstead would amount to very little change at all. Mr. Katz would still need to enter a physical place, as the amendment said, to get protection. Now, granted, it would now be his words that would be protected, so that's different. Katz is different from what lower courts and Olmstead were doing. He'd be protected not just against entry into the space, but he could assert, metaphorically at least, a sort of force field extending beyond him and enveloping all of the information that he intended to keep private. But imagine that he was walking down the street saying to his friend, "The odds are 5-4 that the Celtics win." Well, his intention to keep that between him and his friend just wouldn't matter, because he was on an open street in broad daylight where someone could have heard him with unassisted hearing. So if the court was still referencing a place in their ruling, they'd be heavily qualifying the privacy right that Brandeis had wanted. And they did reference a place. Here's their holding applying their rule, which I discussed just a second ago. Electronically listening to and recording the petitioner's words violated the privacy on which he justifiably relied while using the telephone booth, and thus constituted a search and seizure within the meaning of the Fourth Amendment. So you can see here, the majority ruling in Katz was actually a little ambiguous. As I said, lots of sound and fury about change, but resulting in something that might simply be the rule that Katz had to enter a constitutionally protected area in order to invoke the Fourth Amendment. And that led to a strange turn of events, making Katz really unusual among Supreme Court cases in that the rule that really came to be remembered from this case actually came from a concurring opinion, not the majority opinion that I just read you. So we're actually going to start our next video with the rule articulated by Justice John Marshall Harlan, and we're going to see how it clarified the ambiguity that I just talked of between a place or property-based ruling and a privacy-based ruling. So tune on in for that video, in which we'll also cover our next two cases as well. I'll see you then.